All rise. The Honorable Justices of the Supreme Court. All rise. Hear ye, hear ye, hear ye. This court from recess now sitting. The Honorable Justices of the Supreme Court.
Good morning. And
All rise.
the Supreme Court.
Hear ye, hear ye,
We're
hear
sending
ye.
out a special
This court
welcome this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
Standing as we have KU, K-State, and good morning, Wichita State. And
all rise.
the Supreme Court.
Hear ye, hear ye,
we're
hear
sending
ye.
out a special
This
welcome
court
this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
Standing as we have KU, K-State, and good morning, Wichita State. And
all rise.
the Supreme Court.
Hear ye, hear ye,
we're
hear
sending
ye.
out a special
This court
welcome this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
Standing as we have KU, K-State, and good morning, Wichita State. And
all rise.
Supreme Court.
Hear ye, hear ye,
we're
hear
sending
ye.
out a special
This court
welcome this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
Standing as we have KU, K-State, and good morning, Wichita State. And
all rise.
Supreme Court.
Hear ye, hear ye, hear ye.
Special
This court
welcome this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
And during their 3
KU,
years of undergraduate
K-State,
education,
and good morning, Wichita State. And
all rise.
Supreme Court.
Hear ye, hear ye, hear ye.
Special
This court
welcome this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
and during their 3 years
KU,
of undergraduate
K-State, and good morning, Wichita State. And
all rise.
Supreme Court.
Hear ye, hear ye, hear ye.
Special
This
welcome
court
this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
and during their 3 years
KU,
of undergraduate
K-State, and good morning, Wichita State. And
all rise.
Supreme Court.
Hear ye, hear ye, hear ye.
Special
This
welcome
court
this morning
from recess
because
now
we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
and during their 3 years
KU,
of
K-State,
undergraduate
and good morning, Wichita State. And
All rise.
Supreme Court.
Hear ye, hear ye, hear ye.
Special
This
welcome
court
this morning
from recess
because
now
we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
and during their 3 years
KU,
of
K-State,
undergraduate
and good morning, Wichita State. And
All rise.
Supreme Court.
Hear ye, hear ye, hear ye.
Special
This
welcome
court
this morning
from recess now
because we
sitting.
have a room full of college.
The Honorable Justices of the Supreme Court.
and during their 3 years
KU,
of undergraduate
K-State, and good morning, Wichita State. And
All rise.
Supreme Court.
Hear ye.
May it please the court, the state of Kansas, the appellee appears by Assistant District Attorney Claire Thibodeau, present and ready for argument.
Second case is appeal number 125740 in the matter of the wrongful conviction of Robert William Dols. Shawnee County briefs both sides.
Good morning. May it please the court. Greg Turigny on behalf of appellant Robert William Dols, present and ready for argument.
Please the court, Deputy Solicitor General Dwight Carswell appearing on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes our 10:30 a.m. docket.
Thank you, Mr. Shima. I'll ask counsel in 125006 State v. Stewart to come forward. As they do so, I'll explain a little bit about the court's presentation of the arguments culminates sort of a study that the court members have done of the cases. We have briefs received from the parties. We have records from the lower court proceedings, as well as research memoranda that we have available to us through our own staff. Through that, we have some fairly deep familiarity with about the case, the facts of the cases that we'll hear today. And this gives us an opportunity to probe deeper into the arguments of the parties and ask the attorney some questions. That, we'll ask Mr. Edinger to come to the podium so we can start with that. We'll try to let him get started before we ask the first question, though.
May it please the court, I'm Ryan Enninger, appearing on behalf of the defendant, appellant Doelz Stewart. With the court's permission, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
Thank you, Your Honor. Doelz Stewart brings this direct appeal before the court today, having been convicted of felony murder with the underlying predicate offense of distribution of marijuana. Doelz, I guess I should say I would like to start by just focusing on the first issue raised in our appellate brief. Unless the court had additional questions regarding the second issue, I would submit that on the brief. Doelz submits that this court must reverse this conviction because the state failed to prove the element of possession to establish the offense of distribution of marijuana. Furthermore, as a second prong of that argument, we are arguing that even if the evidence was sufficient to prove possession, the evidence remained insufficient to prove distribution because the state failed to put on any direct evidence of what Tyrell intended to do with that less than 25 grams of marijuana that he attempted to acquire on the date in question. I think I'd like to take a quick moment and just run through the facts of the case. At trial, Tyrell's friend Hannah testified that her friend Emilio contacted her through Facebook asking Hannah if she would like to buy some marijuana. Hannah agreed, arranged to meet with Emilio. Hannah, my client Tyrell, 2 other individuals then went to meet with Emilio to purchase the marijuana. When they arrived, my client on this particular instance was seated in the front seat. The other passenger, Hannah, was driving, 2 other passengers in the back. Emilio approaches the front of the car. The testimony is that my client Tyrell hands him $50. Emilio hands my client the marijuana. Hannah testifies at that point they go to pick up her sister Cheyenne from work. Once they picked up Cheyenne, they return to my client Tyrell's residence, where she says that her friend Bones rolls a blunt and that they all smoke it. After this, sometime afterwards, it's made, apparently my client, this is the testimony from Hannah and Cheyenne, my client wants to purchase more marijuana from Emilio, a larger amount, this time $200. So they, once again, Hannah contacts Emilio. They arrange to make another purchase. At this point, it's only Hannah, her 17-year-old sister Cheyenne, and my client Tyrell, who's seated in the back seat now. They go to meet with Emilio. Just as they're driving up to meet him, my client hands Cheyenne, who's seated in the front seat, the money. Is the testimony that both Cheyenne and Hannah said at trial. At that point, Emilio approaches the front passenger side window. He hands the marijuana to Cheyenne. Cheyenne hands him the $200. But at that point, Emilio says, "This money's fake," snatches the marijuana back from Cheyenne, turns to go back into the residence, and that's when Hannah and Cheyenne claim that my client then fired a single shot out the window, striking Emilio and taking his life. It's well established.
Was the marijuana in possession of Cheyenne?
And I think that's the critical question, Your Honor. And what we've argued is absolutely not. Possession, it's well settled.
Actually, you said an exchange occurred and he snatched the marijuana back. So that does imply that it was physically possessed by Cheyenne. Is that right?
It sounds like from
and the exchange of whether it was true currency or fake currency also.
I think that matters, right?
I don't think it matters, but that occurred also.
That did.
Okay.
But I think what I want the court to focus on is what control means. So possession, it revolves around the idea of control. Well, what is control? Control is maintaining some influence or authority over something. There has to be some sort of temporal period there beyond what we're arguing beyond a here, no. As far as this transaction goes, obviously, Emilio wasn't pleased with the consideration here. This is fake. I'm out of this deal. This is wrong. So our argument there is that because there was no maintaining of any authority, that doesn't rise to the level of legal possession.
Let me ask you a question under 215701Q, which is the definition of possession. I don't see anything in there about maintaining.
Right, but it speaks of control. So if what I'm saying is the definition of control is to maintain
Where are you
authority.
getting that definition?
Control me.
There's a there's a citation in your brief that defines,
No, I haven't defined in the brief control. I'm just saying as part of my argument for the question is what is possession? Possession revolves around control. Control is a matter of maintaining some sort of authority.
and then
or-
you cite to Webster's for that?
Not in the brief, no, I'm sorry, I'm just making that argument this morning.
So your argument is that Emilio never let go, never relinquished control of the marijuana.
Not in a sufficient manner to establish legal possession. The testimony from Cheyenne was, or from Hannah was that it was just in her hand. Cheyenne said it was momentarily in her lap. At that point, Emilio immediately grabs it back. And I think it's consistent with this court's opinion in the holdings and opinion in State v. Crosby, in Hilliard, and in Mora, where that marijuana never became fully under the control of the prospective buyer. And at the end of the day, when the person is shot and killed, where's the marijuana? It's still with the person who's there to distribute it, not with the person that was supposed to be buying it, which is the same exact situation that we have in this case.
Let me move you over to the distribution question. We got possession, but then we still have to have the intent to distribute or transmit it. Seems pretty obvious to me, reading the state's closing argument, that it thought distribution was the sale of the marijuana by Emilio to the car. And I think our case law doesn't support that. But I want to figure out whether the state maybe stumbled over the finish line despite itself. You have no problem with jury instruction number 6, which is the distribution.
Yes, right.
The
Jury
elements.
instruction number 6 says while he's in the commission of distributing
Okay.
marijuana.
So the fact that they had a party and they were smoking marijuana, and they go buy some more marijuana. He wants to go buy some more marijuana. Why isn't that enough for a reasonable inference that he was going to, and that's the argument that the state, that's kind of the fallback issue for the state, or the argument. Why can't you make a reasonable inference?
I think
that
I
he was just buying it in order to share with his friends.
if I understand what you're saying, Your Honor, basically, and that's what the state's argument is that we can presume, we can make a
We can
reasonable
infer.
inference, right?
There's no question they were having a smoking
Well,
party.
I think if we really carefully parse the record, that there has to be some presumption there, because the state never asked a direct question, was Terrell smoking marijuana with you? She said, and if we look at that first transaction, my client's not the one who instigates it. Emilio contacts Hannah. Hannah, and the state's relying on that whole first transaction, that whole first situation, for an inference that my client was going to distribute marijuana.
Well, he's the one that paid for it.
Well, I don't know if the record fully supports that. He handed him the money, and I'll remind the court that when they got back there, Bones is the one who rolled the blunt, not my client. So apparently he wasn't in possession of it when they returned, or at some point Bones is the one with the marijuana when they get back, because he's the one that's rolling the blunt that they're smoking. So
You don't think that's circumstantial evidence of him possessing and distributing?
I think it's pretty thin. I mean, sure, he may have possessed it for that moment when he handed him the money and took it back, but it's very, I think it's based on a presumption, not necessarily a reasonable inference. There's a hole there, a big hole, that the state never could have said, did Terrell smoke marijuana with you? She said, we. Now I've seen lots of, it's very important when I read transcripts, when people are being on the stand and they're being questioned, and they start saying things like we and they and us and them, counsel will frequently stop and say, look, we need to be specific of who we're
Why is
talking
it
about.
important whether or not he
Because it-
spoke with them?
Because that's engaging in distribution. He could have gone to his room and smoked some by himself. We don't know from the evidence here. That's my
But
argument.
but if he purchased it and then he goes to the house and distributes it and doesn't smoke any himself, isn't that still distribution?
No, I think you're misunderstanding what I'm saying.
I'm sorry.
I'm saying that the evidence is that if he, okay, let's say he purchased it.
Okay.
So we get back to the house.
Okay.
The testimony is that from Hannah directly. Bones is the one that rolls the marijuana.
Okay.
Now, there's no testimony about where my client is at that point. Nothing. He could be in his room. Now, and that's my argument. There's no, that, when the marijuana is being smoked, it's, when they are sitting around smoking, that's where the distribution's occurring. There's no evidence directly that my client was there. It's all based on this presumption that by they and we, she meant to include my client.
I
The
thought
state never asked that
I
question.
thought the testimony was that he was smoking the first batch of marijuana because he liked it and
True.
wanted to buy a little bit
But
more.
I still have to argue that there's no testimony that means he was smoking it with anybody else other than himself. And when the state says that he goes to purchase that next, so when he goes to purchase that next, less than 20, there's no statutory presumption. We know it was less than 25 grams. So there's my argument, there's really nothing more than inference stacking here to get to the point that my client intended, or not even intended, but was distributing marijuana when he made that.
And that's where I want to focus you.
Okay.
Walk me through what's being stacked. In order
What's
to
being-
stack inferences, we got to have more than one.
Right.
That's
right.
why I was
So-
focused
Right,
on.
so I think there's at least three,
Okay.
basically three of them here. The first one is that, okay, because he purchased the marijuana from Emilio, according to everyone else's testimony, handed him the money, and took the marijuana. That means that the same marijuana that they got back to the apartment with was the marijuana that Bones rolled the marijuana joint from, was the marijuana that my client allegedly purchased. So there's an inference. We don't know. The state never asked. So the state never asked. So the marijuana that you purchased from Emilio, was that the same marijuana that you smoked when you got back together? There's a huge hole there. And then the second inference goes right back to that. Now they're back at the apartment. The next inference would be they, meaning to include my client, all smoked it together, the same marijuana. And then the third is because of that, he was going back to purchase it in order to distribute it again. So there's at least, that's where it starts to stack up. The state could have very easily clarified that. It could have asked. So that's the same marijuana that you guys smoked, what you bought? Yes or no? When you say we, does that include my client? Where was he? Did he go into his room? And just the fact that he liked it, well, he could equally cut the same way. He wanted to go buy more, keep it for himself. So I just think that the whole premise there is based on inference stack. Hope I laid that out in a way that you can appreciate what I'm saying. Beyond that, I think essentially that is the crux of my entire argument. First, in summation, we don't have sufficient maintenance of control to equal legal possession. That marijuana, just like in the court's precedents in Crosby, in Hilliard, and in Mora, that marijuana was was with the distributor at the time of their death, just like this case. And there's just no evidence beyond, the state didn't put on any direct evidence to establish distribution.
But in those three cases that you cited, would you agree that the purchaser never was in possession?
Right.
And it was like, either in a room or it was on
It was on a dashboard.
dashboard, so
It was
nobody.
on a dashboard. The other person
Okay.
still had it like in their jacket pocket, that sort of thing. So, I mean, but I think it's more consistent with those cases regarding the question of possession than it is on anything else that I could find. So with that, I see I'm out of time. Thank you, Jan.
May it please the court, the state appears by Assistant District Attorney Claire Thibodeau. Stewart did have joint control and possession of the marijuana during the second deal through Cheyenne, and Stewart did intend to distribute that second purchase of marijuana with his friends. The testimony from Hannah, if you look in the transcript on record 10, page 34, Hannah says, "We were all smoking." She had indicated who all was at the apartment, herself, Stewart, Juliana, Bones, that they were all smoking. Hannah indicated that in her testimony. That was after the first deal, the $50 deal. Then Stewart asked for more marijuana. He asked for $200 worth of marijuana and buy two. In the Facebook messages in between Hannah and Emilio, Hannah is saying along the lines of, "We ain't want to cop a lot at first till we knew it was cool. He just cashed his check and wanted more." Hannah was talking about Stewart wanting more marijuana. There is a reasonable inference that Stewart bought that $50 worth of marijuana, distributed it to his friends back at his apartment. There's a reasonable inference that his plan to purchase $200 worth of marijuana was to go back and share it with his friends.
What, was there a, what's the time frame?
I believe it's a few hours.
And is that in the record?
Yes.
That all, everything from first buy to the killing occurred in the space of a few hours?
Yes, Hannah and Cheyenne testify. By one is before they pick Cheyenne up from work. They go back and smoke. They pick Cheyenne up around 5 p.m. And then by two, I'm not sure if there's an exact time, but they said it was dark, but it is the same night.
And in terms of the second transaction, was there testimony in the record that the Emilio actually had turned away and then somehow observed something questionable about the currency? Or what are the specific, or what is the specific testimony around that transaction, that second transaction?
Hannah was in the driver's seat, Cheyenne was in the front passenger seat, and Stewart was in the back passenger seat. The testimony was that Emilio tried to open the back passenger seat where Stewart was, and then Stewart was like leaned against the car. So he ended up, Cheyenne rolled down her window. The deal was done through the front passenger window. Stewart handed Cheyenne the money. Cheyenne handed the money to Emilio. Emilio handed the marijuana to Cheyenne on Stewart's behalf. It was his deal that he wanted. Cheyenne had possession and control of the marijuana. I believe the testimony is that Emilio felt the money, said something along the lines of, this isn't right, then grabbed the marijuana, and as he was turning away was when he got shot. The possession part of it is that possession is having joint or exclusive control with knowledge and intent to have such control. Stewart requested the second deal. He requested it from Hannah to set it up. Hannah brought Cheyenne, her little sister, along. And because of where they sat in the car and where Emilio came to the car, Cheyenne was doing the deal on Stewart's behalf. He had handed her the money. He had requested basically all of the deal to happen through Cheyenne. He is the impetus for this entire deal. He wanted to have control, and the state's position is that he had joint control of the marijuana with Cheyenne. There is no temporal limit on how long Cheyenne and Stewart had to have that joint control of the marijuana.
Let's focus on the distribution aspect. You never introduced any evidence that there was an intention to share with any, right?
No, I think it's a reasonable inference.
And you didn't even argue to the jury that it was a reasonable inference that they were going to share, right?
Correct.
How is it even an inference? Because that's such a small amount of marijuana. It seems perfectly reasonable to infer that Tyrell smokes marijuana, likes it, and wants some more for his own personal use. That doesn't seem to be that outrageous of a leap.
I think.
Doesn't
oh,
the state have to have some kind of evidence that there was an intention on Tyrell's part to distribute the marijuana after he obtained it?
I think it can be an inference. The case law is clear that the intention, there has to be something, an inference or something. To me, the fact that there was a first buy and a second buy is what makes that inference reasonable, because they set up a $50 buy for less marijuana. There's evidence that they all smoked it together.
Is there evidence they all smoked that marijuana together? Or is this a BYOB party?
I think it was clear that it was that marijuana. I agree that that exact question was not asked, but they went to buy marijuana. They then smoked
What
marijuana.
makes it clear that they weren't all bringing their own product?
Because they all went together to the buy. They were all at the apartment. Hannah talks about how herself, Stewart, Juliana, and Bones were all at the apartment. They all left together.
They were all at the first buy.
And they all went, yes. Hannah, Bones, Juliana, and Stewart were all at the first buy, because there's the other testimony about them going to Gage Probosco's house on accident. So all of them were present at the first buy. The second buy, Cheyenne was not at the first buy. Cheyenne was then picked up from work after buy one. And then buy two was Hannah, Cheyenne, and Stewart. So they were all together at buy one. Juliana, Bones, Hannah, and Stewart.
Does that run afoul of the holding in State v. Mora? That when defendants jointly buy and share drugs, they're not distributing?
I think it's distinguishable from Mora. I also think because the second buy was only Hannah, Cheyenne, and Stewart, that the inference is that they were going back to the apartment where the other people were to share it. The inference, they weren't going to only share it within the three. I believe Cheyenne had no interest in the marijuana. She just went with Hannah because she was her sister.
So it's distribution if the friends don't come car, but if the friends were in the car, it wouldn't be distribution.
I respectfully disagree that sharing marijuana among friends is not distribution, but I think in this case it is specific that Stewart was buying it to go share with the friends both in the car and back at the apartment. The facts in Stewart are distinguishable from Mora, Crosby, and Hillard. In Mora, they set up a drug deal and then immediately pulled a gun and demanded the drugs and shot the dealer. There was no possession. The killing was immediate in Mora. In Crosby, the bag was on the center console or the dashboard. There was no money involved, and the defendant immediately said, "Give it up," and shot. That is distinguishable from the facts in this case where the deal was ongoing. It was happening. There was possession. There was money exchanged. Mora and Crosby were, when the killings were done, before a deal could even happen. They had set up a deal. That is clear what they were doing in Mora and Crosby, but it had not begun in Mora and Crosby.
But wasn't the underlying predicate, I mean, I might be wrong about this, trying to remember those cases. Wasn't the underlying predicate felony an attempt in those cases?
I don't believe so.
And it was attempted distribution, right? Or am I wrong?
Oh, in Mora, it was attempted distribution.
So whether the killing happened, I mean, that's why that argument doesn't necessarily distinguish those cases. Because the underlying question was, were they guilty of the felony upon which the felony murder was predicated? And I think at least in Mora, it was an attempted distribution. You have the same legal issue at hand.
In Mora, it was an attempted distribution. In Crosby, I believe it is.
But do you see my point about?
Yes. I still think the facts in this case are distinguishable from that, but, I do think Crosby was charged like this case was charged. And in Hillard, there was absolutely no evidence. In Hillard, this court ruled that she was conspiring to basically distribute to herself, like I have talked about with the inferences, with the one inference, that Stewart did intend to distribute that marijuana. He was never just purchasing to be a possessor or a user of marijuana. He was always engaged in that distribution to possess with the intent to distribute that marijuana.
Does the whole notion of joint possession or joint control, I don't know, on the one hand, it may, that's your argument to satisfy the possession element, but on the other hand, at least logically, doesn't it also suggest in terms of the distribution question that they're all also unified? Do you understand that
Yes,
question?
yes, I understand your question. I think it was more of where Cheyenne was sitting in the car. I think it's pretty clear from Cheyenne's testimony that she was not interested in the marijuana. She just went with her sister, that these were Hannah's friends, not Cheyenne's friends. She didn't want to hang out with these people. She just stayed with her sister. The deal was Stewart was handing her the money to be done on his behalf, but I do think they did have joint control, but she didn't really want to have joint control. Did that answer your question, or?
Well, I don't know. I think the notion that if you can sort of look at them as a collective unit in terms of satisfying possession, shouldn't it sort of logically be the same approach to the distribution question then, in terms of those actors being unified in their, in their conduct?
I think the difference between the joint possession between Cheyenne and Stewart is that if Stewart had completed the sale, had the marijuana, he would have taken it back to his apartment, shared it with Bones and Juliana and Hannah, and not necessarily shared it with Cheyenne. I think that is the difference. And thank you for asking that a second one.
And all of the arguments you're making today are not the arguments you made at trial.
Correct.
The state prosecuted this case as if the distribution occurred when Emilio walks up to the car with the bag of dough, with the bag of weed, and hands it to Cheyenne. And Tyrell hands the money to her. That's the distribution, because you say it doesn't make any difference if you're the buyer or the seller. I'm reading your closing argument. That's what you thought the distribution element was, and that's what you argued to the jury, right?
That is what was argued to the jury, yes.
So, now we're really just trying to backfill, provide evidence of a required element of this offense.
And I think the evidence was there, even if it wasn't directly argued in the closing argument. The evidence was there. The testimony was given about what could and was going to happen with the marijuana.
There's no evidence about what was going to happen to that marijuana, right?
The
That's
inference.
the thing. You never asked. Were y'all going to go back to the place and party some more? Or did you intend to be able to share some of that marijuana that Tyrell's getting? None of those questions were asked. And that's why I'm not even sure it's an inference, reasonable inference at least, to say that the intent was to go back and share that small amount of marijuana with anybody, that it's just personal use. It seems to me to be just as reasonable that he was buying that for himself.
I think based on the amounts, the $50 deal and then the $200 deal, I also think based on what was said in the Facebook message about they didn't want to get a lot until they knew it was good. I think based on those facts that did come out at trial, that it is a reasonable inference that he was going to go share it back with his friends. Unless anyone has.
Couldn't you just as reasonably draw the opposite inference? In other words, if they shared the first buy when everyone was there, couldn't you infer that they weren't going to share the second buy since not everyone was there?
I think that's an inference that could be made, but I think at a sufficiency of the evidence, you have to look at all the light in the evidence in the light most favorable to the state. And unless anyone has any questions on issue 2, I will stand on my brief on that. Thank you.
Thank you. You reserve 3 minutes.
Unless the court has specific questions for me, I would be willing to yield the time that I have.
What's your memory about this Facebook message? So
What I remember about the
Pull
Facebook
it out.
before
I go and pull it out, I just wondered
which aspect, because there were several.
Well,
It started
counsel
on-
just said the Facebook message to buy the second batch of marijuana.
Something about, we didn't
We
want to get a lot.
we wanted a taste
Well,
before.
I mean, first of all, that's a Facebook message. The state never asked, is that what Terrell told you? And that's just, so there's a problem with that's a Facebook message that Hannah said. That's Hannah's description. That's Hannah's. I don't know how you can even contribute that to necessarily to my client's statement when the state never tied it directly to my client. Hannah could have said, well, we just didn't want to get a lot at first until we knew it was good. I don't think there's any way to, the state could have said, oh, and about that Facebook message, is that what Terrell told you? That, well, now he just wanted to make sure it was good, or did she just tell Emilio that to put him at ease about a larger amount? We just don't know. And I think that's really the crux of so much of what I'm saying about the inference stacking problem with the state's argument, is those questions were never asked to really flush out what a lot of these ambiguities are. The evidence is just not there because those questions weren't asked. Court, I would surrender the remainder of my time.
You're asking for us to reverse the conviction. Would this be then a sufficiency where there's no remand and no new trial? What would occur?
Well, if there's insufficient evidence of the predicate felony, there's insufficient evidence of that the murder was, that's a missing element. So it's a reversal. It's a sufficiency reversal. That's the end of the story. Thank you.
Thank you.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement, which means that later today we will discuss the case. A justice will be assigned to write the opinion, and the court's discussions will continue until we finalize the opinion, or perhaps opinions if there are differing views about how the case should be decided. Once that occurs, we will issue a press release about the decision being filed, and the opinion itself will be on the kscourts.org website where everyone can read and view it. So, thank you, counsel. We'll now call 125740 in the matter of the wrongful conviction of Robert William Dols.
Morning. May it please the court. Could I please reserve 5 minutes for my rebuttal?
5 minutes is reserved.
This case is about time. Time is valuable. Time is a resource that you can't spend, or I'm sorry, that you can only spend. You can't buy. And once you spend it, that's it. The state of Kansas took 4 years of Robert Doles' life away from him. This case is about attempting to compensate him for that time. The statute itself bases the damages on the amount of time that the claimant was incarcerated. That's the background of this case. My client, Robert Doles, is not a stranger to this court. In 2019, this very court overturned his conviction and released him from prison. It is that decision by this very court which has led the parties here today. Robert Doles' appeal admittedly is on an extremely narrow issue. But I think it's important to lay out the foundation how we got here. In 2019, this court ruled that the state of Kansas illegally gathered evidence from a vehicle in which Robert Dols was the driver. That evidence was deemed the fruit of the poisonous tree and could therefore not be used against Robert Dols. Shortly thereafter, Robert Dols' adjudication was dismissed by the Leavenworth County Prosecutor's Office. The search of his vehicle was illegal, and therefore his subsequent confinement and conviction were illegal. We are here today on an appeal of the trial court's ruling that Robert Dols failed to show evidence that the reason for the dismissal of his criminal adjudication was because he did not commit the crime for which he was convicted. Where I believe all the parties in the trial court agree that the statute's poorly written. Now that we found some common ground, why don't we get into why we all disagree? The trial court and the state are incorrect in their interpretations of the statute, holding that resulted in subsection C means because of, and that it is the controlling word in the paragraph. When we look at the statute and we look at the plain language of the elements of the claim, the statute does not say anything regarding the reason behind the dismissal. The state and the trial court are attempting to read in the word because into the statute. Trial court holds that Dols must have proven the reason for the dismissal of his criminal case was because he did not commit the crime.
Is that what they're saying, or are they just saying that and means and subsections B and C are joined by an and? So under B, you have a dismissal for whatever reason, but under B, you still have to show that the claimant, that your client did not commit the crime.
Yeah, and so I think that's where our argument in the state and the trial court's argument differ. We're not arguing that we don't have the burden of proof by a preponderance of the evidence that he didn't commit the crime. What we are saying is that the state's interpretation that we have to prove why his case was overturned is the issue. So they've argued that it's surplusage. B is you need A, B, C, and you're done. Well, C, subsection C, essentially states he did not commit the crime, he was not an accessory, and then it goes into resulted in, right? What we are arguing is that they're reading in this because definition to resulted in, right? They're saying that because he did not commit the crime, his case was dismissed. His case was reversed, or his case, or he was found not guilty on retrial. What we are arguing is that that's not the point of the statute. The point of the statute is to compensate people who are wrongfully convicted. And if we have to get into the mental state of a jury who made a claimant or granted the claimant to be not guilty, you know, it's something that is not contemplated by the statute, and it goes beyond what the statute is trying to convey.
Let me ask you a question. Number one, you know, we have to interpret the statute, and we use the plain language of the statute. So let's just say that subsection C of 60-5004 stopped after it says that the claimant must prove by a preponderance of evidence that the claimant did not commit the crime. Let's say it just stops after that. Okay, so none of this because of that the reversal or the judgment was vacated or anything. What evidence is there? What evidence did your client present that he didn't commit the crime?
I think the only evidence in the record is the evidence we put forward. We didn't even get to the state's case in our trial. The only evidence was the evidence we put forward that, you know, his quadrant of the car was clear. A witness saw the backseat occupant of the vehicle the night before with the exact same parcel of drugs. The only evidence before the court, in the trial court, is the evidence we put forward of his lack of knowledge of the drugs.
Is that
lack of possession?
But I mean, we just in the previous case talked about possession.
Mm-hmm.
It's his car, right?
It was his girlfriend's car.
Okay, and it's in the gas tank or whatever. I mean, that's possession.
Right, and we put forward evidence that he was not the person who pumped the gas. We had another occupant of the car testify as to who possessed the,
But it's like joint possession. I mean, he's driving the car. You know, I can't see a circumstance, you know, or preponderance of the evidence that he didn't commit the crime. I mean, you know, the whole thing is, I mean, he committed the crime, right?
no, and I think that's where we disagree with everyone is, you know, my client from the get has been saying that the drugs weren't his, right? And that he wasn't aware of the drugs, right? He
Right, but
testified
a
that.
jury found that he did.
Yes, and then, you know, subsequently that case was overturned.
It was overturned not because of sufficiency of the evidence. It was overturned because, you know, because of a collateral issue that had to do with an unlawful search and seizure, right?
I agree.
But on the underlying issue about whether or not the claimant committed the crime, a jury found the claimant committed the crime. Correct?
I would agree with that, yes. However, we've had a change in testimony from witnesses. We've also, you know, supplied evidence. I believe that after his criminal trial, there was a motion for retrial where people even said that the drugs weren't his. They came forward.
And was
witnesses-
all that
witnesses-
evidence presented at the civil hearing under 5004?
We had two witnesses testify, if I recall correctly, testify that the drugs did not belong to Robert Dols and Robert Dols himself. So the only evidence before the court, before our case was kicked, was evidence that we put forward saying that he lacked the knowledge or the possession of the drugs in the car. We, you know, put forward evidence that he didn't pump the gas, and the last person to touch the gas cap before they were pulled over was someone other than Robert Dols. That was all evidence that we put forward. And I don't even think the trial court kicked us on whether or not he did the crime or not. You know, we understand that it's our burden to prove under the preponderance of the evidence that he didn't commit the crime. What we're trying to say is that we were kicked because they wanted us to step into the mind of the prosecutor and say why his case was overturned, when the point of the statute is to compensate people who were wrongfully convicted, not, you know, derail them through the complications of court proceedings.
Well, why did the legislature include this language then? Resulted in a reversal or vacation?
So the state actually addresses that in their brief on page 8, where they talk about the Michigan statute. And so the Michigan statute talks about new evidence. And it seems that when Kansas, you know, sort of adopted this language, not sure if they adopted all of it or if it was something that they looked at, but the Michigan statute is alarmingly similar. The Michigan statute requires new evidence. And resulted in addresses new evidence. The new evidence resulted in a reversal, dismissal, or a not guilty verdict, right? If you look at resulted in the Michigan statute, it makes sense because it's addressing some new thing. When you look at the Kansas statute, it's gone. There's no new evidence to address, right? There's a verb without a subject. The resulted in is just there. You know, and in the state of Kansas admits it in its own brief that that's kind of how it is that it changes it. So what they're trying to do is read in a because to the did not commit the crime. They're saying that's why the adjudication needs to be overturned, is because they did not commit the crime, right? We're not saying that we don't have to prove that he didn't do it. We're more than happy to do that on remand. The issue is that we were kicked, you know, to quote the trial court, the reason for the dismissal was because because he did not commit, the reason for the adjudication was dismissed is because he did not commit the crime, right? That's what they are trying to allege. They're trying to make it so that the the reason for the dismissal of the adjudication is because he did not commit the crime,
In a
as
case-
opposed to us having the opportunity to prove that he didn't commit the
Okay.
crime.
So in a case where you have, a murder, a mass murder, or, and there's one key eyewitness, and there was, a trial error, I don't know, jury misconduct, something happened, and it is, it's reversed. We reverse it, and it's gonna go back down for a new trial, and the one key witness died. And so the prosecutor's like, I can't retry this case, so I'm not gonna retry it. And that person's been in jail, the mass murderer, for 4 years. So you're saying that, even though it, then you're gonna make that same argument that, even though that the fact that the claimant didn't commit the crime, even though that wasn't the reason, for the reversal, then that person gets compensation?
What I'm saying, and I understand where you're going, the question. But yeah, as the statute's written, that's how it would have
As
to
the way
be.
you interpret the statute.
As the way I interpret it, yes.
You're saying that
No, but the implication here is that any case that we hear, or the Court of Appeals hears, that is reversed, a conviction is reversed, and then results in either an acquittal at retrial or not a prosecution, basically ends up where you're at. Is that where?
Where the person has the opportunity to prove their innocence, and I don't even think it's innocence, it's actually, they did not commit the crime, yes. I think that's how it's written, and that's how it is, because they're reading in this because that shouldn't be there, because
As opposed to actual innocence. You got the wrong person.
it does, it says did
Well,
not commit the crime.
I may just be confused. The way I understand your argument is that the district court committed a legal error by reading into the statute an element that is not there. That element is that the reversal of the conviction was because the defendant did not commit the crime.
Did that much better than I could, yes.
And if that's your argument, I mean, is that what happened? Is that what the district court did?
The district court, our case, because they said that we did not put forward evidence that his criminal adjudication was dismissed because he was innocent.
And can you like read from the district court's ruling or cite to where in the ruling specifically? Because I do think this is helpful to me, at least. I think I understand your argument. Your argument is not that one of the elements of your claim is that you prove by a preponderance of evidence that your client did not commit the crime.
So, because claimant has failed to prove a necessary element of his claim, there's no need to address these elements, right? Claimant did not offer any evidence that the reason for the dismissal was because he did not commit the crime for which claimant was convicted. That's their whole dismissal.
It just strikes me that that's a very simple argument, and you don't even need to get into this whole question about the second half of subsection C.
I think that's very.
Does that render the second half of subsection C just surplus? We give it no meaning? We just, in essence, we strike it from the?
I think that you could possibly do that.
Well, isn't the meaning, I mean, I don't know, but Justice Standridge offered some pretty compelling hypotheticals, and it strikes me that this is aimed at preventing someone who procures the dismissal by illicit means. I mean, someone who hires takes out a key witness or something.
So I believe if it's subsection D or actually something where it says did not bring about his own, did not bring about his own conviction, did not suborn perjury.
Yeah, that's
know.
the opposite. That's the, I'm gonna get myself convicted so I can later recover a huge sum.
Right.
But C is, again, I'll just posit this as a hypothetical possibility. It strikes me as it's possible that this language is aimed at preventing someone from recovering who, by illicit means, caused the conviction to be reversed, or caused there to be no charges filed on after the reverse. That's the hypothetical I think was being discussed earlier of, you've caused a mistrial because you've tampered with the jury, or you've killed a key witness on retrial, or some nefarious act. I mean, doesn't that make sense with the language in subsection C?
That scenario does make sense, but I don't.
It's not relevant to this case.
It's not relevant to this case, but it's also,
Doesn't it require us to read into the statute something that's not there?
I think what happens, beyond this case is a fascinating question for the statute. But what I think is happening, is that because language, the reading in that they're asking you to do, while it's saying, not to say that it would necessarily be that there would be nefarious means to, I don't think that prevents that. The reading that they're doing is because they are trying to say that you have to get into the mind of the jury, mind of the prosecutor, mind of, the Supreme Court perhaps, who let this person out of jail in the first place, right? That's why the conviction was overturned. I think one of the big things in this case is, where I don't think the second half of the statute is surplusage, right, is because it outlines 3 paths to recovery, right? It outlines reversal, dismissal, new trial, right? Not guilty upon new trial. When you get to not guilty on new trial, it would make that possibility a legal fiction. It would make saying, okay, you got your case reversed and then you went to a new trial. And the only reason you were found not guilty on new trial, is because you were innocent. No jury could ever deliver that. It makes that part of the statute nonsensical, right? No jury could ever say you're innocent. No jury could ever say you did not commit the crime. The only commentary juries give us in America is not guilty. And so that's where I think, if they put these 3 separate paths in there that you can have after your adjudication ends, they must all be viable, and we must all take into account, that the same probable cause and same burden of proof has to apply to all claimants, right? You can't look into the mind of a prosecutor who dismissed it and then, say, okay, well, you got retried, you're good. It has to be the same burden of proof across all of them. And they put these in there, these possibilities in there. So they must be interpreted. We must interpret the statute in a way to make it viable.
But that also means giving some meaning to the word resulted. And I think that's the problem. To me, that's the problem, because there's a word missing. What resulted? There is nothing that tells us what has to go before that causes the result, right? Because grammatically, it just doesn't fit with the first part of that section, nor does it fit with the umbrella language of A. Something is missing, but under your interpretation, what are we doing with the word resulted? Are we just ignoring it?
I think any definition of resulted other than because would require a remand in this case. Because unless it is because, and it addresses did not commit the crime, then any other definition besides that, we've hit all the elements, and that would change the district court's ruling for why we're here, right? We are here on that narrow issue of resulted in means because.
Is that even a legal thing? Like, do get reversed because the person didn't commit the crime? I don't, not really a thing, is it?
Doesn't sound right to me.
I mean, convictions get reversed because the error was committed.
Right. And I think that,
Sufficient evidence.
yeah, and so it would make it
Is
nonsensical.
insufficient evidence the same as the defendant did not commit the crime?
No, and I think that's why we still have to go prove that. But, I think the statute has to be interpreted in a way that makes sense, in a way that makes it fair. And if we interpret it their way, then really it makes it pretty difficult to state who can claim under this statute, because we would have to look into the mind of whoever issued.
Well, in your case, you wouldn't have to look into the mine. You could have just called the prosecutor.
So we subpoenaed him, or attempted to serve him as subpoena before trial when I looked at it.
What if it means that it doesn't have to be that exact same crime, but it has to be same acts that led to the charges that led to the conviction? So what I'm saying is that it says the claimant did not commit the crime or crimes for which he was convicted, and not an accessory or accomplice to the acts that were the basis of the conviction that resulted in reversal. So it has to be, if you interpret it as the acts underlying the conviction and not the specific conviction.
With the because, is that what? Or just the
Doesn't
statute,
mean
or just
because.
with the
It
statute?
means that we're talking about the same facts that led to the charges that led to a particular conviction. But the meaning that the legislature is trying to evoke is not that it, because it resulted in reversal or vacation, but that it relates to those specific facts that eventually led to the conviction.
So I would say that in response to that, I think that would still go back to, we still have the burden of proof,
But
right?
what if, for example, he was convicted of felony theft for stealing an emerald? Turns out that they didn't charge a lesser included of a misdemeanor, but it turns out that the emerald really isn't worth at least $1,500.
I think then you could, that's interesting, because different parts of the statute say different things as to whether it's the crime charged or whether it's not. And I would say that would go into the burden of proof, that we have to prove that, yeah, sure, you don't have to prove that you committed the crime charge, but you can also, you have to.
You have to prove you didn't steal the emerald. That's the point.
I would say no. That would be on the prosecution at the time of the case to charge you with that. I think there was already a case that was, this court's already ruled on that with a burglary charge. I forget the name of the burglary charge. Had legal access to the building, and they didn't charge him with the lesser included, and he.
Your point, you only have to prove that he didn't steal an emerald that's worth at least $1,500. You don't have to. So if you prove the emerald is worth less than $1,500, you get 4 years worth of compensation, because you may have stolen the emerald, but it was only worth $500.
Yeah, if we can prove that. I think that would be the definition that, based on this statute, works.
But if you read it the way that I just suggested, that subsection
C requires you not only to prove that valuable emerald, you have to prove he didn't steal emerald, because that also could have been charged.
Yeah, I believe that I'm agree. Because of the accomplice liability in that second part, you know, you have to say that he was. I think that does go against a previous ruling of the court where they didn't include the lesser included.
It please the court, Deputy Solicitor General Dwight Carswell appearing on behalf of the state. This statute is, as the district court noted, poorly written. But that doesn't mean it can just be ignored. It must mean something. The phrase resulted in is clearly referring to something must have resulted in either the reversal or vacation of the conviction, dismissal of charges, or finding of not guilty on retrial. And the only plausible interpretation is that resulted in is referring back to the first half of the sentence, everything that comes before it. In particular, the requirement that the claimant did not commit the crime. There is no other.
Is that, Justice Siegel, you're asking your question.
Yeah, I was
More,
gonna
in a
ask
more,
my
in a
same
more precise way than
I don't know that
asked
it's
mine
very
earlier. but
precise.
You go first and I'll follow up if I need to.
The way I put it to your opposing counsel is that even a thing? I mean, that's not very precise, I guess, but I've never heard of a reversal because the defendant did not commit the crime. I've never heard of that.
Well, it doesn't mean that the appellate court would have to find that the person did not commit the crime, but that would be what was caused it. So the finding would be insufficiency of the evidence, or it could.
Insufficiency of the evidence is not, it's not a finding that the person.
That's what I'm saying. The appellate court would not need to find that, but if the person did not commit the crime, that would cause insufficiency of the evidence. That would be what's behind that.
It never be a finding that that's the reason why there's insufficient evidence because the defendant didn't commit the crime.
Right, but what the statute is, the statute does not say the appellate court has to find that the person did not commit the crime. It says that the fact that the person did not commit the crime resulted in reversal.
Well,
So if the person did not, oh, go ahead.
Do you agree with what your opposing counsel, how your opposing counsel recited the district court's ruling in this case?
Yes, I would just say here it was not just about reversal. It was either reversal, dismissal of the charges, or finding
But
not.
you agree that the lower court found as a matter of law that for the claimant to prevail, he had to satisfy as an element that the dismissal was because he did.
One of those three things, reversal, dismissal, or the finding of not guilty, which wasn't an issue here.
How would any person ever meet that element if that were an element?
The third element or any of the three?
Any of
So with the first one, as I was going before, I mean, if a person did not commit the crime, that would result in a finding of insufficiency of the evidence. Again, that's not what the appellate court finds, but that's causing that.
Let's just say
because
let's just say everyone under the sun agrees for whatever reason that that a hypothetical defendant did not commit a hypothetical crime.
Yes.
That's unquestioned. But it's also clear from the appellate court decision reversing the conviction that the reason it was reversed was because of some constitutional issue that had nothing to do with it.
Well, in that case, then it wouldn't be satisfied by reversal, and then you'd have to look at the reason why it was dismissed. And if it was dismissed because, if the prosecutor says, well, I'm not going to go forward with this case because it's clear that this person's innocent, then you would show under
If the prosecutor never says, I mean, that strikes me as the state's taking a position that if your conviction gets reversed for any reason other than that you didn't commit the crime, King's X, you don't get to recover under this.
I mean, if it gets reversed for some other reason, like say, I don't know, ineffective assistance of the counsel, then it goes back to the trial court. Then the question is, well, what happens at that point? I mean, if it goes, the prosecutor looks at it and says, well, I want to retry this case because I think the person's guilty, and it goes to trial and it's proven that the person's innocent, well, then that person could potentially, based on other things, recover. But if it's set aside for other reasons. Like a Fourth Amendment violation. If the reason why the case does not go forward is because of these other reasons, then yes, they would not be able to recover. And we think that's not only the best textual reasons, as I'll get back to, but that's also, if you look at the legislative history, what the legislature was getting at, what motivated this law, where there were particular instances where people's convictions were set aside because it was determined that they were innocent.
Actual innocence.
Actual
That's what I'll
innocence.
follow up on.
Yes.
Did they accomplish that with this statute? Let's just say Mr. Dole's case got dismissed because of the Fourth Amendment violation. But it turns out he wasn't even there. It wasn't him. How does he get relief under this statute?
He would not if it was solely because of the Fourth Amendment violation. But again,
But he wasn't there. He's actually innocent. Served 4 years of his life in prison for a crime that he was nowhere around, had the wrong guy. Does he get relief under this statute?
if the reason for reversal and dismissal was solely the Fourth Amendment violation, then no. That's different than the situations which motivated the
It said
legislature.
the intent of this statute is to compensate people who were wrongfully convicted who are actually innocent. How do you get that?
Mr. Carswell, is an example like Lamont McIntyre, where either a wrongful eyewitness situation or DNA evidence comes up, and there was, where we didn't have DNA before, but then now there's DNA, and these are situations where there is actual innocence, just like under our habeas statute, where it is actual, the example being that he wasn't even there, that, we now have availability of technology to zoom in, and then you see, oh my goodness, he wasn't there. That's somebody else. Is that really what the statute is aimed at?
Yes, people whose convictions were set aside because of actual innocence, like Lamont McIntyre or the other examples, Floyd Bledsoe and Richard Jones, sorry. People that's the reason why their convictions were set aside, was because they were actually innocent, not people whose convictions get aside for other reasons and then later come in after the fact and say, now I'm actually innocent. And part of the reason why the legislature, that's a policy decision as to why they might want to make those distinctions. But one good reason to do that would be, well, now after the fact, if it's set aside if your conviction's set aside because you're actually innocent, then that's already been established to some extent. If you're coming in after the fact, your conviction has been set aside for other reasons. It now no longer really matters whether you're guilty or not, because your conviction's gone and the state can't re-prosecute you. And you're claiming that you're innocent now, and the state then essentially has to retry you in a civil case. Granted, it is your burden, but you just have to say I'm innocent, and then the state has to go and basically in the civil case put on a whole trial to show no, you're not, if they actually believe you're guilty. Then that's putting quite a burden on the state. It's causing victims to have to testify again. So the legislature could reasonably make this distinction. I'm not saying whether it's right or wrong, but it's certainly a policy distinction that the legislature could reasonably make, and we think they did reasonably make, and say this statute is only available to provide compensation to people whose convictions were set aside because of finding of innocence.
Doesn't
Not
that render surplusage the language in the statute that requires the claimant to establish by preponderance of the evidence that they did not? If you've already got if under subsection B, you have your conviction reversed because you're actually innocent, why go through the pantomime of having to prove by a preponderance of the evidence that you didn't commit?
I suppose it could be because maybe a prosecutor thinks in some situations that, like, hey, I think this person's innocent, so I'm not going to go forward with this prosecution. But then in a later case, they come forward, and maybe at that point there's additional evidence that they actually did commit the crime. So the state at that point is saying, well, even though the prosecutor dismissed the charges because we think you didn't commit the crime, actually it turns out on further discovery that we think you actually did, so we don't want to provide you your compensation after all. So there could be some gap there. I will also note that this statute does appear to be modeled after the Michigan statute that we cited in our briefs. There's nothing directly saying that, but there is this statute, including this language as it was originally introduced at the request of the Innocence Project. And the Innocence Project testified that this statute reflects the best of what other states have done. So we know at least parts of the statute were modeled on other states. And then the similarities between this statute and the Michigan statute, these particular provisions, not overall, but these particular provisions seem similar enough that it's just too much of a coincidence to have been random. And the Michigan statute does use the phrase new evidence that shows the person, demonstrates a person did not commit the crime, and that new evidence must have resulted in dismissal or reversal or these other things.
That's not in our statute.
Exactly. And then this statute takes out the new evidence language, but it does still require a person to prove that they did not commit the crime by some evidence, by preponderance of the evidence.
So let me ask my textual speculative question, I guess, which is, we're focused on subsection C. It seems pretty clear to everyone that it's hard to make sense of it. If we just change, not we, but if hypothetically, if you were just to change the word "and" between the words conviction and resulted to an "or," does that make the whole thing make sense?
I don't think so, because then the resulted would be referring to back to
In other
acts.
words, let me just run by what I'm thinking. The first part of this goes to Justice Wilson's question, which is, even if you are innocent of the actual crime, you still can't recover if you still did something bad. You stole the emerald that was a fake emerald, it turns out. You can't recover. You're an accessory or an accomplice to the acts that were the basis of the conviction. And then if there's an "or" there, that last part, to me, suggests the legislature not wanting to let somebody recover who did something that interfered with either the prior trial or a second trial. That was Justice Standridge's question.
I don't think so, because then the "or," I think that would more naturally make the resulted in, I mean, it would still, what's that referring to? The acts that were the basis of the conviction, but
Acts
being the
acts
accessory.
that resulted in the reversal. You could just strike, you could read the sentence, just take out the words that were the basis of the conviction, or I'll just read it. Was not an accessory or an accomplice to the acts that resulted in the reversal or the vacation of the judgment of conviction. That makes sense to me. Am I wrong?
doesn't make sense to me, because I'm not sure the acts that resulted in the reversal would be, I mean, showing you were innocent, essentially. I mean, what caused the reversal would
What
be.
if your friends tampered with the jury? And it's the conviction's reversed on appeal. Then you are responsible for, you're an accessory or an accomplice to acts that resulted in the vacation of the judgment of conviction. The legislature saying, nope, you don't get to recover under those circumstances.
Perhaps I'd have to think about it more. I mean, I do think, though, I mean, the "and" was what was obviously
Yes,
chosen by
that's
the
what's there,
legislature.
so we're
And
fine.
also, I mean, again, I think this is copied from, it appears, from the Michigan statute. So, I mean, I think you'd be radically changing from what the Michigan statute means. Whereas our interpretation is most consistent with what they copied from. I think also, to the extent you think some word is missing, I think what is implied here essentially, as we put in our brief, is essentially a "this" before resulted. So if it's "and this resulted in," so you have to show the claimant did not commit the crime and this resulted in, that's essentially what the statute is reading. So if you have to actually read words in, I think actually this is essentially applied, but to the extent you're reading words in, that's the way to do it, to be both consistent with legislative intent, especially, again, with what happened in terms of how they modified the Michigan statute to adopt it in Kansas, rather than changing "and" or, which I don't think there's any evidence that that's legislative intent.
In other words, the claimant not committing the crime resulted in the reversal or vacation is how you get us there grammatically.
Yes.
That to the interpretation, which I understand that you're advocating.
Yes.
Okay.
And that is how the district court
That's how the district court
construed
interpreted
the
it.
statute.
Yes.
And do you also agree with the argument of counsel that under his alternative interpretation, there would have been error, that because there was evidence presented that under the standard that applied to the district court, viewed in the light most favorable to the plaintiff, would have shown innocence?
So the district court did not actually address whether the claimant committed the crime, just because this was a state moving for judgment as a matter of law.
Okay, but there was evidence presented. Or under on the opposing interpretation.
Dols put on his case. The state had not put on its case yet at the time that the district court granted
Right.
judgment as a matter of law. So I
Right.
think we would have contested whether the district court should have found that he'd met that or not. So we don't know what the district court would have found by preponderance of the evidence as to that point, as to whether he actually was innocent or not. I think our position would be no, he's not actually innocent. But regardless.
The evidence that he presented was not sufficient
Yes.
as a matter of law to show innocence.
It's a matter of fact to show innocence.
But the conclusion, well, yeah. But the standard would be that that evidence that was presented as a matter of law could not have demonstrated the claimant did not commit the crime.
Maybe I'm not. So at the trial, what happened was Dols called a few witnesses, and
Right.
one of them was some of the testimony. I haven't gotten into it too much because that's not what the district court decided.
Right.
Was basically that this was someone else's marijuana. He didn't have knowledge of it. That's contrary to what the jury in the first trial found, of course, and the state had contrary evidence. So that all would have been something that would have needed to be determined if there actually were a full trial at the end of that.
Yeah, had there been a full
Yeah, yeah.
trial, but which obviously didn't happen, but I was just trying to get to the standard of review, I guess, that would have controlled under his interpretation of the statute. At that point, the time of the trial, the judge should have, if under the competing interpretation, you would just look at his evidence in the light most favorable to the plaintiff at that point in the proceedings.
I mean, I think if, under his interpretation, if you essentially just ignore the second part of the subsection, which is what I think he's essentially arguing for, and just look at whether the claimant committed the crime or not, then that's a fact finding that the district court would need to do. And because the district court's acting as a fact finder, it would be essentially a sufficiency at the evidence review by this court. Yeah. One other point I just wanted to make before closing, I see my time's out just quickly, is to the extent there is any remaining ambiguity, and it sounds like the statute is very confusing, you do need to keep in mind that when the state waives sovereign immunity, those waivers need to be construed strictly. So if there is ambiguity, that needs to be construed against liability here and not broadly to require the state to provide compensation.
Was there a case cite for that proposition?
There was one Kansas case, Brown versus State Highway Commission, and then several federal cases were applying the same principle that flushed that out a little more.
And that's in your brief.
Those are in the brief, yes.
Thank you.
Sure. Was there any further questions? Ask that you affirm the district court. Thank you.
You.
Counsel, I'll just jump right in since we just talked. What would your response be to what State's Counsel just said at the very end there, which is that if there's an ambiguity, constitutional considerations require it be construed against liability?
In regards to sovereign immunity, the statute itself is a waiver by the state. Statute itself is the state waiving
Right, but
liability
it's,
on this.
I understood the state to be making an argument, like a rule of construction argument, which is because there's these constitutional concerns, as a rule of construction, we would construe ambiguous statutes against a finding of liability.
Yes, and I don't have a case to dispute that. However, I think where that applies to this case is that we can still look to the statute, and the definition that they want is not asking this court to construe it against liability. It's construing it to not make sense. Regardless of liability, it's construing it to make it nonsensical. And that's why. So for construction purposes, I do think that the statute should be narrowly tailored, like the state says. However, I think that it also has to be construed in a way to make sense. And, it's not part of my brief, and I apologize, but I had anticipated some questions this morning. At its heart, the test for vagueness is a common sense determination of fundamental fairness. So I think statute's vague and it doesn't make sense. But I think we also have to interpret it in a way that makes sense and is fair to every person who would bring a claim under the statute. And I understand that our interpretation would mean that there are a lot of potential claims. But we still have to interpret it in a way that makes sense. You know, we talked a lot about the intent of the state. Well, you know, I can intend to eat a salad for lunch. When I get to the restaurant and I order a meatball sub, you know, my cardiologist have to deal with the actions that we took, not the intent of me gonna eat a salad. I don't get points for the intent, right? So when we look at this, you know, they intended it to be actual innocence and all of these things. They didn't put it in the statute, right? They didn't put, innocence doesn't occur until we get to, the word innocence doesn't appear in the statute until you get down to certificate of innocence, bottom. It doesn't talk about that. It talks about not commit the crime. And then when they put the words in there in subsection C, they made it to be nonsensical. And so we're asking, you know, the court to remand us with a definition that it's any other word but because, and it makes sense, right? But this because makes the whole thing surplusage. And it makes it nonsensical, and it makes it for a claimant who might well, you know, not have committed the crime, right? Regardless of how he gets to this point, unable to claim under this statute. I think your analogy earlier, you know, makes sense where, right, what if Robert Dols wasn't even in the car that day or something along those lines, right? But he got dismissed because of a Fourth Amendment violation. Well, you can have your case overturned by a Fourth Amendment violation and still be innocent of the crime. Like, the two are not mutually exclusive. You can do both things. A claimant can be both things at once. It's not you're innocent, oh, but you know, we violated your constitutional rights. It can be both. And I think that is why I'm here, and that's why we're going through this. And I want to thank the court for their time on this bizarre issue and this really thorny legal issue. And I appreciate your attention to it because it's, you know, a younger lawyer, but this is the most bizarre statutory interpretation I've had to deal with so far. And unless if there's no more questions, I'll yield my time back to the court.
Thank you to both counsel for your arguments. The court will take this case under advisement. The court is now in recess until 9 a.m. tomorrow morning.